UAS, commonly known as drones, and discuss how federal agencies are working together to combat this evolving threat. We will also examine what additional authorities and resources the Department of Homeland Security and the Department of Justice need to successfully counter UAS while working together with the Federal Aviation Administration. In recent years, the market for commercial UAS has rapidly expanded due to the affordability and utility of drones that are readily accessible to government, to industry, and to recreational users. The FAA estimates that by 2024, about 2.3 million UAS, including 1.5 million recreational drones and model aircraft, and about 800,000 commercial UAS will be registered to fly in the U.S. airspace. Between 2016 and 2019, airline pilots reported on average more than 100 drone sightings per month to the FAA. The increase in the number of UAS operating in our airspace creates higher risk of rogue drones either failing to obey safety rules or operating with nefarious intentions, threatening manned aircraft operations, airports, critical infrastructure facilities, and high-profile, widely attended events such as sporting events, concerts, and more. While most individuals operate their drones responsibly, we have already seen careless and malicious actors misuse these technologies to engage in reckless or criminal activities. In September of 2017, a privately operated drone in Brooklyn, New York, was intentionally flown beyond the operator's line of sight and collided with a U.S. Army Black Hawk helicopter patrolling a temporary no-fly zone around New York City. Thankfully, the Black Hawk and its crew landed safely, but there was significant damage to the helicopter, and the incident created an unacceptable risk to the service members in that helicopter. In 2019, a drone significantly disrupted flight operations at Newark Liberty Airport for 90 minutes, causing 9 flights to be diverted, halting 43 planes inbound to the airport, and also causing significant delays for passengers. These events demonstrate the severity of the threat posed by UAS, and if we do not act, it could only be a matter of time before someone who is recklessly operating this technology causes an accident that can have catastrophic effects. And as we work to avoid unintentional disasters, we must also account for the escalating threat of weaponized drones from terrorist and criminal organizations who could launch domestic drone attacks on mass gatherings, high-profile landmarks and buildings, or federal property. This includes foreign adversaries who have deployed drones in conflicts abroad and could have the capability to deploy them here in the United States as well. We must also be prepared to counter drones operated by criminal organizations that are reportedly using UAS for illegal activities, including trafficking illicit drugs across our borders. I am grateful to my colleagues who have led past efforts to address these concerns and to improve the safe integration of UAS into American airspace, including Senator Johnson for authoring the Preventing Emerging Threats Act. Since 2018, the authorities created by this law have bolstered our nation's ability to protect numerous large public events, including the Super Bowl, from UAS threats. Today's hearing is an opportunity to discuss renewing and updating these authorities, which are set to expire this October, as well as Biden's administration's domestic counter-UAS National Action Plan, the first coordinated whole-of-government plan to address the evolving security threats posed by UAS. I'm working on bipartisan legislation that I plan to introduce in the coming weeks to reauthorize and strengthen counter-UAS authorities to better tackle this threat. Today, I'm pleased that we have a panel of expert witnesses from DHS, DOJ, and the FAA who can discuss what lawmakers can do to ensure the federal government is better equipped to safeguard against potential threats from UAS. I'd now like to recognize Ranking Member Portman for his opening comments.
Thank you, Mr. Chairman. Thanks to the witnesses for being here. Look forward to hearing from you. We're here today to discuss the emerging threats posed by unmanned aircraft systems, or drones, In 2018, under the leadership of Senator Ron Johnson, who's here this morning, we provided, as Congress, some new authorities to the Department of Homeland Security and Department of Justice to counter the threats posed by the use of drones. Unfortunately, those authorities are about to expire, and this expiration could not come at a worse time, in my view. Cartels and transnational criminal organizations use drones to smuggle drugs and surveil U.S. law enforcement in furtherance of illicit cross-border activity. These cartels have also begun to weaponize drones in order to commit attacks. So far, these attacks, as far as we know, have been in Mexico. But I think weaponized drones along the border are now an emerging threat. To give you a sense of the scale of the problem, in joint testimony before the House Committee on Homeland Security in March, representatives from DHS said that in a previous 5-month period, CBP identified more than 30,000 individual flights near or at the southern border, where half of those flights violated FAA regulations. Again, we know that at a minimum these drones are used for surveilling our U.S. law enforcement efforts and for smuggling drugs into the country, including fentanyl, the deadly synthetic opioid. Relatively small amounts of it can kill hundreds of thousands, millions of people. So it's subject to being smuggled in relatively small drones. My office has repeatedly asked DHS since February of this year for more information and statistics on these drone border incursions and how they plan to address this emerging threat. Moreover, the Biden administration's Domestic Counter-Drone National Action Plan provides no explicit additional authorities for DHS to counter unmanned aircraft systems as it pertains to the border. Make no mistake, the Mexican transnational criminal organizations will benefit from the lack of additional counter-drone authority for CBP and other agencies with responsibility for securing our nation's borders. For these reasons, I'm eager to hear how DHS, DOJ, and the FAA have used their existing authority to mitigate the threats posed by illicit use of drones. I also hope to discuss what new authorities this committee can give the administration to improve the counter-drone mission, especially at the border. Recently, the Biden administration provided this committee with a comprehensive legislative proposal which seeks a number of changes and expansions to existing counter-drone authorities. I look forward to working with Senator Peters, Senator Johnson, and other members of this committee to review this proposal. The committee has already done good work to address the threat to national security and economic competitiveness posed by Chinese-made drones when we reported out the Bipartisan American Security Drone Act last year. Among other things, this legislation would prohibit the federal government from purchasing and using drones manufactured by our adversaries. I'm very concerned about reports of the purchase by DHS and DOJ law enforcement of Chinese drones and the national security risks that this poses. I'm pleased that our legislation that we reported out of committee, but has not yet gone to the floor, is included in the Senate-passed USICA package. And I urge our leadership, particularly Speaker Pelosi in the House, to swiftly pass USICA so this can become law. With that said, I look forward to a productive conversation about the current drone threats to our homeland and actions being taken to prevent them. I look forward to hearing from the witnesses. Thank you again, Mr. Chairman.
Thank you, Ranking Member Portman. It is the practice of the Homeland Security and Governmental Affairs Committee to swear in witnesses. So if each of you would please stand and raise your right hand. Do you swear that the testimony you will give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may be seated. Today's first witness is Samantha Vinograd, the Acting Assistant Secretary for Counterterrorism and Threat Prevention and Law Enforcement Policy in the Office of Strategy, Policy, and Plans at the Department of Homeland Security. Ms. Vinograd began her career serving President George W. Bush as the Deputy U.S. Treasury Attaché to Iraq and subsequently served on President Barack Obama's National Security Council as Director for Iraq, Director for International Economics, and Senior Advisor to the National Security Advisor. Previously, she was a CNN National Security Analyst, a Senior Advisor at the Biden Institute, and a Visiting Fellow at the University of Chicago Institute of Politics. Ms. Vinograd, welcome. You may proceed with your opening remarks.
Chairman Peters, Ranking Member Portman, and distinguished members, thank you for inviting me to testify about the Department of Homeland Security's efforts to protect the homeland from the increasing threat posed by unmanned aircraft systems, often referred to as UAS or drones. Today, I will explain how the Department has relied on authorities granted in the Preventing Emerging Threats Act of 2018 to counter the malicious use of drones, and why we are asking Congress to reauthorize and expand our counter-drone authorities to fill specific gaps that are exposing the homeland to serious threats. We are committed to judiciously and responsibly implementing our authorities so that we can stay ahead of the threat while protecting privacy and civil rights and civil liberties in absolutely everything that we do. The threat landscape from drones is heightened and candidly escalating extremely fast. Drones have been used to conduct dangerous kinetic attacks, have interfered with aircrafts and airports, have been used to survey, disrupt, and damage critical infrastructure and services, and more. Nearly every day, transnational criminal organizations use drones to convey narcotics and contraband across U.S. borders. In fact, CBP has detected more than 8,000 illegal cross-border drone flights at the southern border just since August 2021. In light of this threat environment, it is critical that DHS have the authorities to protect the homeland from UAS threats, consistent with our statutory missions. To date, DHS has relied on the Preventing Emerging Threat Act to carry out critical CUAS mission sets, including protecting the President and Vice President, safeguarding sensitive assets, facilities, and special events in the maritime sector, protecting federal facilities and personnel, and countering illicit narcotic and contraband trafficking. Based on our experience through over 300 deployments, there's clear evidence that there are gaps in our authorities which are exposing the American people to significant risk. For example, even though the Transportation Security Administration, or TSA, is responsible for protecting airports, it lacks authority to proactively and persistently protect transportation infrastructure from drone threats and avert disruptions and real tragedies. This is especially concerning since TSA has reported nearly 2,000 drone sightings near U.S. airports since 2021, several of which have resulted in pilots taking evasive actions, 65 evasive actions, in fact, and the disruption of airport operations. Furthermore, state, local, tribal, and territorial law enforcement are often the first responders when a malicious drone incident occurs, but they are not currently authorized to detect or mitigate drone threats, thereby delaying a response. Critical infrastructure owners and operators are often the victims of drone surveillance and have even been targeted for kinetic attacks, but they have no authority to detect drones or to request mitigation from authorized law enforcement. Bottom line, our partners are absolutely critical to protecting the homeland from UAS threats, but lack the authorities to do so, which again exposes the homeland and the American people to significant risk. DHS, therefore, strongly supports the administration's legislative proposal to reauthorize DHS's and DOJ's current CUAS authorities, as well as to expand them to remedy the gaps that I've identified. It would grant TSA the authorities it needs to protect the nation's transportation system from UAS threats. It would also authorize SLTT partners and critical infrastructure owners and operators to engage in detection of CUAS. Lastly, it would create a limited pilot program for SLTT law enforcement to engage in CUAS protection activities in their jurisdictions under the strict oversight of DHS and DOJ. The proposal would require that authorized SLTT and critical infrastructure owners and operators adhere to comparable safeguards and standards to those that we federal entities follow. Non-federal entities would be required to use federally approved equipment, receive standardized training and certification, conduct risk-based assessments, coordinate with FAA to ensure aviation safety, and very importantly, adhere to federal privacy, civil rights, and civil liberties protections. We just cannot keep pace with this threat environment without these additional counter-drone authorities. It just isn't possible. And we hope that this committee will champion them. Congressional action is urgently required as our current authority will expire in less than 3 months, and a lapse would be catastrophic. I thank the committee for holding a hearing on this important topic and look forward to your questions.
Thank you, Ms. Vinograd. Our next witness is Brad Wiegman, Deputy Assistant Attorney General in the National Security Division at the Department of Justice. Mr. Wiegman brings a wealth of government experience, having served in legal positions at the Department of Defense and the National Security Council over the span of 2 decades. Previously, Mr. Wiegman worked at the private law firm of Shea & Gardner, where he focused on civil litigation and legal policy matters. He's also served as a law clerk for Judge Patrick Higginbotham on the United States Court of Appeals for the Fifth Circuit. Mr. Wiegman, welcome to the committee. You may proceed with your opening comments.
Thank you, Chairman Peters, Ranking Member Portman, members of the committee. Thanks for the opportunity to testify today on behalf of the Department of Justice. We strongly support the administration's legislative proposal to allow us to continue to protect major national events and important department facilities from the threat posed by misuse of drones. This legislation would also enable us, as Assistant Secretary Vinograd just said, to expand our counter-drone efforts, both with respect to the types of facilities that we can protect and to empower our state and local partners to participate in this critical mission. So we understand at DOJ that drones are bringing great benefits to our society and our economy. But like many advances in technology, drones also bring serious risks to the public when they're misused. As has been alluded to already in the opening statements, we're seeing an increase in the use of drones for a wide spectrum of criminal and other dangerous activities. They can be weaponized to conduct attacks using firearms, explosives, or other materials. They can conduct cyber attacks against wireless devices or networks. And they can conduct espionage or trafficking in narcotics and contraband. Beyond these nefarious uses, drones are often used carelessly to create hazards to the public. Let me just give you a few recent examples. In February 2020, a subject was arrested and charged in connection with his efforts to use a drone to drop explosives near a Georgia mobile home park. Between September 2021 and February 2022, 4 defendants pled guilty to a conspiracy to deliver contraband via drones into Fort Dix Prison in New Jersey. We've recently seen Mexican drug cartels using drones to drop bombs on their rivals in Mexico, as well as to traffic drugs into the United States. In May of this year, a defendant was sentenced after using a drone to drop flyers over spectators at 2 separate NFL games in California. And it obviously could have been something much worse than flyers. Under the current authority that Congress has granted, the FBI has conducted 70 counter-drone protection operations at large events, ranging from the Super Bowl to the New Year's Eve celebration in Times Square. That represents only 0.05% of the over 121,000 events during that time for which an assessment was requested so that counter-drone support could be provided. So the demand for counter-drone support has far outstripped the federal government's limited resources. During those 70 operations by FBI, our counter-drone teams detected 974 non-compliant drones in restricted airspace. They located the operator in 279 cases, and the attempted mitigation against 50 drones. Now, our current authority, as Chairman Peters mentioned, to counter drones expires in October if it's not extended by Congress. The reason we need this authority is because our use of this technology would otherwise run afoul of various criminal statutes. So our legislative proposal, would extend our current authority permanently and would expand it to address some critical gaps. Now, I just want to talk about a few of those briefly in my opening statement. First, as has been mentioned, the legislation would authorize state and local law enforcement and owners and operators of critical infrastructure to use certain detection-only capabilities. We need to empower others to help us take on this responsibility. Notably, the detection-only technology does not jam or otherwise disrupt drones or other aircraft, and therefore it does not pose any risk to the safety of the national airspace. This can be safely done today. Second, the legislation would authorize a limited pilot program for up to 12 state and local law enforcement entities each year to engage in both detection and mitigation activities. By mitigation, I mean actually interfering with the flight of the drone. This would allow our state and local partners, to protect sensitive state facilities and mass gatherings in their jurisdictions. Now, the participants in the program would be required to receive training and vetting and to follow the same rules as federal agencies must currently follow. And all of their activities would have to be coordinated in advance with federal partners, including the FAA, which could withhold approval if there was a risk to the national airspace. Third, the legislation would enable the Marshal Service to protect high-risk prisoner transports. Current authority covers our prisons and our courthouses, but it doesn't expressly address high-risk prisoner transport, so it would fill that gap. Finally, I want to say a word about privacy and civil liberties. We're committed to ensuring that we respect all constitutional rights and privacy as we conduct our counter-drone activities. The technologies we employ typically detect only communications being passed between the controller and the drone to direct its activities. They do not extract text messages, email, or internet search histories from phones or tablets used to control drones, nor do they allow us to listen to voice calls. We typically collect information such as the drone vendor and model, the controlling device serial number, the geolocation of the drone, the location of the controller, and the most recent takeoff location. This is much like the information that's going to be required to be broadcast by the new remote ID rule and is currently required for manned aircraft. As is required in current law, DOJ would continue to have guidance that contains express protections for privacy and civil liberties, and state and locals would be required to follow these same rules. I appreciate the opportunity to testify today and look forward to answering your questions.
Thank you, Mr. Igman. Today's final witness is Tonya Caltes, Deputy Associate Administrator for Security and Hazardous Material Safety at the Federal Aviation Administration at the Department of Transportation. In her role, she provides executive oversight of national security policies, plans, and programs involving manned and unmanned systems, in addition to several other security-related topics. Ms. Caltes has over 30 years of combined local, state, federal, executive, and military experience supporting defense, intelligence, safety, disaster response, and crisis management efforts. Previously, Ms. Caltes served as a senior executive for the DHS National Protection and Programs Directorate, now CISA, at the Office of Infrastructure Protection, and for FEMA. Ms. Caltes, well, welcome to the committee. You may proceed with your opening remarks.
Can you hear me? My speaker. Sure. Okay. Plan B. Chairman Peters, Ranking Member Portman, and members of the committee, thank you for inviting me to speak with you today about the FAA's role in assuring safety, security, and efficiency of the nation's airspace as it pertains to unmanned aircraft systems, or UAS or drones. At the FAA, we are constantly working to welcome these beneficial new technologies into the national air system, while minimizing any impacts to our existing air transportation system and to the public. Every day, commercially operated UAS contribute to our economy by inspecting infrastructure, supporting agriculture and other industries, assisting public safety agencies, and conducting a myriad of other tasks. Congress has recognized these tremendous benefits to our economy and society and has been fully supportive as we integrate this technology into our airspace in a safe and secure manner. However, the FAA does acknowledge the potential misuse of this technology poses unique security challenges that enable malicious actors to exploit vulnerabilities or circumvent traditional ground-based security measures for our security partners. For that reason, Congress authorized the Department of Defense, Energy, Justice, and Homeland Security to use technologies designed to respond to UAS that pose a threat within their mission responsibilities. You are directed, the FAA, to work with these agencies to ensure that detection and mitigation measures do not compromise the safety and efficiency of the airspace. The FAA's chief role is to support our partners' testing and eventual use of these detection and mitigation systems, many of which use radio frequency and other technologies that could potentially interfere with air navigational systems, communication, avionics systems, which are all critical to safety of flight. Along with developing our plans for certification of UAS detection and mitigation systems, the FAA is also tasked with testing and evaluating these technologies for potential use near airports. We and our security partners have developed agency-specific and jointly agreed-upon processes to determine when, how, and what detection or mitigation technologies can be safely used in a particular location. We also developed notification protocols to be used during an active detection or counter UAS event. The administration's proposal to expand UAS detection and mitigation authorities so that other federal departments and agencies, as well as other public and private critical infrastructure entities, will be able to use tested systems to safely protect sensitive facilities, operations, and people from the malicious or errant use of UAS. The proposal, which the FAA does support, would, among other things, give limited UAS detection-only authority to the non-federal law enforcement community, as well as airports and critical infrastructure owners and operators. It would also create a temporary pilot program for non-federal law enforcement to begin using UAS mitigation technologies under federal oversight. In addition, the FAA would be authorized to assess civil penalties against those who use detection or mitigation technologies in an unauthorized manner that endangers the national airspace. All areas of new or expanded authorities include robust safeguards to ensure the current level of safety in the NAS is preserved. We recognize that expanding UAS mitigation authorities beyond our current federal partners will present challenges. And for that reason, the proposal for the pilot program reflects an incremental approach to evaluating such authorities and safeguards that include interagency coordination on participant selection, training of system operators, and requires program participants to work through DHS and DOJ in coordination with the FAA. There is no question that a seamless security framework is critical to advancing the administration's goal of fully integrating UAS into the NAS, maximizing the public benefits from this technology. By taking deliberate steps to support those entities with duties to protect against emerging UAS-based threats, the United States will continue to lead the way in the full integration of UAS while maintaining the safest, most efficient, and most secure airspace system in the world. We thank the committee for its leadership on this issue and look forward to working together to balance safety and innovation with security.
Thank you. Ms. Caltes. Well, this committee is constantly focused on all of the threats that the Homeland faces on a daily basis. And clearly, the three of you have outlined significant threats posed by UAS. But my question for you, Mr. Wiegmann, is how would the FBI assess the potential threat from UAS along the threat spectrum? Is this low, is this medium, or is this high, and why?
I think what I would say, and as the FBI director has testified before, this is a very significant threat. Given the easy ability to buy a drone commercially, it's easy to get, they're very easy to use, and not that difficult to weaponize for as we've talked about, and that's what we're seeing some of already. So the FBI director predicted a few years ago that we would see a drone attack on a mass gathering. Happily, we haven't seen one yet, but I think it's a matter of time until we do see that type of misuse of drones for an attack in the United States.
Thank you. Ms. Vinograd, in your testimony, you discussed the potential use of UAS as both weapons as well as interference tools that could target airports as well as other types of critical infrastructure here in the country. I'd like you to explain for the committee more specifically what authorities does DHS currently lack to counter this threat, and what should this committee focus on as we draft legislation to reauthorize the current legislation?
Senator Peters, thank you. As my colleague just noted, the threat posed by the malicious use of drones represents a significant and increasing risk to the homeland and the American people. Currently, under the Preventing Emerging Threats Act of 2018, we are authorized to engage in protective measures against credible threats posed by UAS to the safety and security of certain DHS protective missions. That includes, for example, the protection of government personnel, president, vice president, federal facilities, sensitive assets in the maritime sector and elsewhere, as well as mass gatherings like SEERs and NSSEs in addition. What we have witnessed over the last 4 years as we have judiciously and responsibly implemented our existing authorities is that there are significant gaps in our ability to protect the homeland from drones. We have seen an increasing number of malicious drone incidents in and around airports. We have witnessed 2,000 sightings of drones in and around airports since 2021. Since 2021, aircrafts have had to engage in 64 evasive actions. That includes 4 commercial carriers doing so. There have been 30, on average, 30 airport disruptions each year. And in these scenarios, seconds matter. What we are seeking for the Transportation Security Agency, or TSA, is the ability, based upon this escalating threat environment, to engage in the proactive and persistent protection of the transportation sector, to include airports. This will literally, sir, help avert tragedy. Tragedy both as it pertains to the potential loss of human life and economic impact. When airports have to shut down, that costs millions of dollars. So this will help avert tragedy. Second, we are seeking authority for state, local, tribal, and territorial partners, as well as critical infrastructure owners and operators, to be authorized to engage in the detection of UAS. Those authorities would be implemented under the supervision and oversight of federal departments and agencies. We are also seeking the ability for a time-limited, a 6-year pilot program for state, local, tribal, and territorial partners to engage in mitigation of CUAS. As it pertains to state, local, tribal, and territorial partners and critical infrastructure owners and operators, as the committee knows, DHS relies on partners all around the country to help protect the homeland. We can't be everywhere. What we know is that the threat posed by UAS is widespread across the country, and it is critical that our partners have the authority to help protect the homeland, in addition to TSA getting the authority to critically protect the transportation sector.
Thank you. Well, certainly we know that state and local enforcement agencies need additional authorities. Certainly they're going to be kind of the tip of the spear when it comes to protecting our country from these threats and in working closely with federal government agencies. However, there have been concerns that have been raised by folks that such an expansion creates some significant challenges in terms of training and preparedness. So, Mr. Wiegand, I want to ask this question. The administration's proposal would establish a pilot program to test out these expanded authorities to state and local law enforcement. However, these entities need to have proper training, including how to protect individual rights to privacy, as well as effectively executing this pilot program. How would the Department of Justice ensure that these entities have the necessary training to properly execute these authorities?
Thanks for that question, Senator. Yes, so training is a big part of it. As you recognize, we need to ensure that if state and locals are going to do this, they know how to do it, and they need to be operating under the right rules. So one of the elements of our bill is to establish a training center that the FBI would operate in conjunction with DHS. All of the state and local, first of all, it would only be under the pilot up to 12 entities per year, but we would work with each of those entities that are designated to participate in the pilot program, do the training. They would have to learn what equipment could be used, learn how to operate it, learn what the rules are, because they would have to follow the same federal rules in terms of any data they collect, how it can be retained, disseminated, and used, when they can engage in mitigation activity, what the rules of engagement are. All of those are things they would have to be trained on and then certified. And then even after that point, when they are doing their risk-based assessments as to which facilities or events they're going to protect, that's all subject to federal oversight as well. So this is not the kind of thing where we just hand it off to the states and let them take over. It's something that we, the federal authorities, would continue to be actively involved in, both in training and making sure they're using the authorities appropriately.
Ms. Vinograd, how will providing additional authorities to state and local enforcement better prepare the Department of Homeland Security to protect, let's focus on mass gatherings, such as national security special events and special event assessment rating events?
Senator, as I mentioned, DHS cannot be everywhere. We rely in other contexts on state, local, tribal, and territorial partners to help us protect and to advance a variety of DHS missions. If SLTT partners are granted this authority, they can help prevent catastrophic attacks against mass gatherings of a variety of size and in a variety of venues. As my colleague, Mr. Wiegand, just mentioned, these authorities would be implemented under strict supervision and oversight of the federal government, including ensuring that these individuals authorized to conduct these operations are operating under comparable federal safeguards as they pertain to privacy and civil rights and civil liberties. As I mentioned in the context of TSA and airports, when we're witnessing a drone threat, seconds matter. Currently, SLTT authorities that are on the ground can't detect proactively drones, nor can they mitigate them. Those seconds that I mentioned, Senator, really matter, and the inability of our SLTT partners in their jurisdictions to respond could cost lives if our partners are not granted these authorities.
Thank you. Ranking Member Portman, you're recognized for your questions.
Great. Thanks, Mr. Chairman. Thanks to the witnesses for their testimony. This is obviously a serious issue, and I agree with Ms. Vinograd, who said that a lapse in the authorization would be catastrophic. I think it would help these transnational criminal organizations, among others, and yet we need better data to be able to put together the right authorization to write sound policy. We know already what happens on the border with these drones. We know they're used for deliveries, not just for drugs, but also currency and firearms, other contraband. This committee has, among its responsibilities, oversight of DHS and these border activities, and we have a particular interest, I certainly do, in this issue of the synthetic opioids that are streaming across our border today. The numbers, unfortunately, are higher than ever. Last month, enough fentanyl was seized, which is a synthetic opioid that's killing about 2/3 of those who die from overdoses, which is at a record level. We know that there was enough seized to kill about 200 million Americans in 1 month, and no one on the border thinks that we are seizing most, and not even a significant percentage of what's coming across. So it's a big issue. Ms. Vinograd, question for you. Understanding this increased threat from these transnational criminal organizations, how do you assess DHS's current performance in countering the use of drones for cross-border illicit activity?
Senator, thank you. I share your concern about transnational criminal organizations and the malicious use of drones over the border, both as it pertains to smuggling contraband as well as surveillance of law enforcement, in addition to other threats. Currently, DHS, the Secretary of Homeland Security, has designated 3 areas of operations along the southwest border as covered facilities or assets. This allows DHS, CBP more specifically, to engage in CUAS operations in these areas of operations. We have
Let me be more specific, because I don't have much time. In your testimony, you state that from August 21 to May 22, CBP detected more than 8,000 illegal cross-border drone flights at the southern border. Of these 8,000 flights, how many were successfully mitigated by DHS?
Senator, I can ask CBP to get back to you and your staff with the specific statistics.
Well, we've been asking them for this since February, persistently, and we are not getting the information. So, you know, I think it's important we have an authorization, but we have to have information. If we don't have the statistics today, if you don't have it, despite many, many inquiries from us, that concerns me. I want to work with you, again, on this reauthorization, but we've got to have better information to be able to do it properly. With regard to drones, let's talk about China for a moment. Recently, the directors of the FBI and British M15 warned of the national security and economic threats posed by China. They identified it as our greatest long-term threat, stealing our technology, dominating our markets, and they talked about the U.S. drone market, and they talked about the use of drones. Here's an example. According to a report by Washington Post, China's DJI is the leading provider of drones to U.S. law enforcement agencies, they say. DJI has servers in China. They have support from the Chinese government. The Chinese State Security Services is one of their customers. Here's our own Commerce Department saying DJI has been added to an export blacklist last year after Bloomberg reported that it supplied surveillance technology to Chinese security forces in Xinjiang, where millions of Uyghur Muslims have been forced into internment camps. So there's a report that last year that the Secret Service purchased 8 of DJI's drones. The FBI purchased 18 of them. So let me just ask you these questions on the record. Start with Mr. Wiegmann. Does the FBI currently purchase and use Chinese-made drones, yes or no?
We do.
You do. Ms. Vinograd, does DHS currently purchase and use Chinese-made drones?
DHS has prohibited the purchase of foreign-made drones, small UAS, absent waivers in very specific circumstances.
Okay, so this report that I mentioned said that the Secret Service had purchased 8 of DJI's drones. You're saying that's inaccurate?
I'm saying that with certain waivers, very
So
specific
my
waivers.
question to you is, are you purchasing DJI drones or not, yes or no?
With specific waivers, DHS can purchase certain
Are you
foreign-made
purchasing DJI drones, yes or no?
With certain waivers, we are purchasing certain foreign-made aircraft.
So you are?
I can follow up with more specific details.
Okay,
in a
but the
closed
answer is
hearing.
yes.
In a closed hearing, I can provide more specific details, sir.
Okay. Ms. Caltes, don't want to leave you out. Does FAA currently purchase and use Chinese-made drones?
FAA's responsibility is for the integration of UAS into the NAS and testing of the UAS technology to ensure its safety and its use in the NAS. We don't actually purchase drones. We do
Okay.
the testing of the drones.
Thank you. Again, given what the FBI has told us, what the Commerce Department has told us, what we know from reports, I can't believe we have to write legislation to force U.S. agencies to ban the use of Chinese-made drones, particularly where the servers are in China, where Chinese government is a part owner and a supporter of this particular company. But we do have that in the USICA bill. It's a requirement in the USICA bill, and I hope we can get that legislation passed. If we cannot get that legislation passed, would you all support including this kind of legislation in whatever we do in terms of reauthorization? Ms. Vinograd.
I share your concerns about these drones and would welcome a conversation on specific language, sir, yes.
Mr. Wegman.
So just to be clear, we share the concern as well, Senator. We want to shift away from use of Chinese drones, and the FBI is working, and other parts of DOJ are working on that objective. Right now, they kind of dominate the market, so we're working to shift our use of drones away from Chinese drones to other alternatives. In the meantime, the FBI takes steps to do thorough cybersecurity and supply chain reviews to ensure that any risk posed by use of the technology is mitigated, but we do want to shift away from it. And so we definitely support the aims of the sponsors of the bill. I think we've provided some technical assistance on some technical issues about things we would need to, changes we would make to the bill to make sure that we could support it and could conduct our mission consistent with the provisions, but we share the objectives of shifting away from these drones and using other alternatives that don't pose the same type of supply chain risk.
Yeah, well, thank you, Ms. Wigman. The administration supports the legislation, the USICA legislation, and we did negotiate it, with the administration as well as Democrats and Republicans here in the United States Senate. So we appreciate your support of the broader legislation, and I hope we continue to work with each of you on both of these issues, getting better data as to what's actually happening, particularly along the border, where we have a special interest in this committee, but also with regard to the use of these drones and the potential national security threat of having this information be relayed back to China and used against us. Thank you, Mr. Chairman.
Thank you, Senator Portman. Senator Johnson, you're recognized for your questions.
Thank you, Mr. Chairman. 5 years ago when we were drafting and passing the Preventing Emerging Threats Act of 2018, we obviously understood the threat the drones posed to this nation, the very serious threat. I was very frustrated at the time that we couldn't offer greater authority. I have to admit here, 5 years later, I'm enormously frustrated that we haven't made greater progress, and that we're still taking what I would consider baby steps when, to me, it's out of control. 2,000 sightings around airports, 69 evasive actions. Let's get down the brass tacks here. Let's find out what our capabilities are. Have we, under the current authorities, have we actually brought down drones around the types of events that DHS can counter?
Senator, DHS has engaged in detection and mitigation of drones in and around, concurrent with the authorities.
So we have taken down drones. Have we advanced our technology in 5 years?
We have certainly advanced our technology in 5 years, yes, sir.
Do we have the capability right now to prevent drones from entering restricted airspace around an airport?
Currently, DHS assesses that TSA could respond to an emergency in and around an airport. What we are seeking in the legislation is the ability for TSA to proactively and persistently
Okay, I'm asking what is our capability right now, if you have the authority. And first I have to find out who has the authority to establish a restricted airspace around an airport, around a stadium, around power plants. Who has that authority?
The FAA, sir.
The FAA. Have we established that restricted airspace?
We work with our federal partners as well as our non-federal stakeholders when requested.
Is the airspace around an airport restricted to drone use right now?
Yes,
All airports?
yes.
Do we have the capability of knocking down drones if they enter that restricted airspace? Do we have that capability? Maybe not the authority, do we have the capability technologically?
Technologically, yes. We have the ability to mitigate malicious drone threats.
So shouldn't this legislation at a minimum grant you the authority so we can almost immediately start knocking down drones when they enter that restricted airspace around airports?
Senator, DHS is deeply supportive of TSA getting the authority to mitigate drones around airports.
So now let's just start expanding it, because to me that'd be the #1 priority. Mr. Wegman, there's no constitutional right to have a drone, correct?
No.
You've mentioned civil liberties. What civil liberty issues are contemplated if we're knocking down drones entering a restricted airspace?
Well, we would want to do so responsibly, only when it posed a threat.
Sure, we
Beyond
don't
that,
want to knock them down and create a greater problem, but I mean, there'd be no civil liberties issues if we establish restricted airspace and somebody flies in a drone, they got no civil liberties to worry about. We're going to knock down that drone safely if we can.
I agree,
correct?
Senator. I don't think that presents a civil liberties issue.
I couldn't quite understand.
I agree with you, Senator. I don't think it poses
Okay,
a risk.
so
when
again,
when a drone is flying restricted airspace, to interdict that drone is not a civil liberties issue, in my view.
So in the proposal the administration gave us, have we contemplated the priorities of establishing restricted airspace and granting the authority to be knocking down drones when they enter restricted airspace? For example, I'm contemplating around a stadium on game day. Establish that temporary as restricted airspace so that state and local authorities, working with DHS, have the ability to knock those drones down, take them out of the skies before they pose a threat.
We have that authority now, Senator. That's what we're asking to extend. But yes, we want.
Have we knocked down any drones around stadiums?
When we say knock down, yes, we've disabled them. We've required them to divert and land, or we've interdicted them. Yes, we have at a number of events. As I mentioned in my opening testimony, we have done that. Yes.
Okay. Well, again, my main point here is we've got to move faster, and it's great to have pilot programs, but that's 5-6 years in the future. Trust me, the public is going to demand that we act a whole lot quicker if a commercial aircraft hits a drone that's entered the restricted airspace. So I want to make sure in this piece of legislation we've got that authority, and then the funding and the personnel to start protecting our restricted airspace as soon as possible. Is there anything that's going to prevent that from happening in this piece of legislation?
That's why we're here, Senator. We agree with you, and we are seeking the authority to do just that.
But again, I'm a little concerned about a pilot program that's going to work with 12 state and local and tribal.
It's going to take some time.
I mean, that's a pretty slow rollout, isn't it?
It's going to take some time to ramp up, but it's 12 every year. It takes some time to do the training, to get up and make sure they're doing this and know how to do it and get the technology
Well,
to them, and so forth.
but
It's going to be, they will be able to do multiple missions, and over time, we think that's
My point is, we've already taken 5 years, which I find enormously frustrating. And sure, it takes time, but we can ensure that it takes less time if we prioritize as a serious threat and we establish this as a priority for putting more personnel to make sure it takes less time.
fair.
You understand what I'm saying? So I think 12 pilot programs a year is completely too little, and I'm hoping it won't be too late. So let's look at this piece of legislation. Let's start ramping it up, okay? I mean, we spend trillions of dollars in the federal government. We ought to focus on this because this is a serious threat. And again, I don't want to have it be too little, and I certainly don't want us to be too late on this. Okay, and Mr. Chairman, again, I appreciate you pushing this. I want to work with you to strengthen this. I don't think this is strong enough yet. But let's not have a piece of legislation that's too little, too late. The bill we passed 5 years ago was too little. Fortunately, it hasn't been too late yet. Let's make sure we do a good job on this one.
Absolutely, Senator, and we look forward to working with you. Appreciate your continued leadership on this issue, and
Thank
we'll
you.
make it as strong as we possibly can. We appreciate that. Thank you, Senator Johnson. Senator Hawley, you're recognized for your questions.
Thank you, Mr. Chairman. Thanks to the witnesses for being here. Ms. Vinograd, if I could just start with you. You work in the Office of Strategy, Policy, and Plans, is that right?
Senator, let me just say, I had my first visit to the state of Missouri on Friday.
Oh, good.
Deeply.
Where did you go?
I went to Jefferson City.
Okay.
I just want to share, I was
capital.
deeply impressed by your Homeland Security professionals.
Well, thank you very much.
I look forward to going back. Yes, I work in the Office of Strategy, Policy, and Plans.
And you work with Robert Silvers there, is that right, the Undersecretary?
I do, sir.
Your name is on a memo with Mr. Silvers dated September 13th, 2021. The subject is organizing DHS efforts to counter disinformation. This is the memo that recommended the establishment of the Disinformation Board. It was turned over to me and to Senator Grassley by a whistleblower. I have to tell you, we've had the darndest time getting any information about this board out of your agency. We've asked and we've asked, members of this committee have asked. We would know virtually nothing had it not been for this whistleblower who turned over a tranche of documents, all of which are now public. So since I have you here and you wrote the memo, let me just ask you a question or two about it. Whose idea was it to establish this board?
Senator, the Department of Homeland Security has engaged in disinformation work pertaining to threats to the homeland and the American people for over a decade. With respect to this internal working group, there were discussions about the need to ensure that there were guardrails in place across the department to protect civil rights and civil liberties and privacy. And as such, there were discussions about creating this internal working group.
Well, yeah, all of that I noticed is in the passive voice. My question is, whose idea was it to set up the? And you use the word working group, but I noticed that that's not at all what the memo says. It doesn't call it a working group. The directive that Mr. Mayorkas eventually signed off on does not make this board a working group. It had managerial authority, it had directive authority, all of that's in these documents. So let's please not go back to those tired and now disproven talking points. So let me come back to my question. Whose idea was it to establish the board? Was it yours?
Senator, without going into internal deliberations of the Department of Homeland Security, there were a series of discussions among personnel.
Who?
I'm not going to go into the internal deliberations of the department.
Why not? You're under oath.
I am under oath, sir. That said, these are internal deliberations at the department. As you know, sir, the charter was signed by the Secretary of Homeland Security.
Yeah, I only know that, by the way, because of the whistleblower documents. We would not know that otherwise.
Senator, the charter was signed by the Secretary of Homeland Security. The charter included, the working group included representation.
Does the charter call it a working group, since you bring up the charter?
This was a working group, sir.
Does the charter call it a working group?
I don't recall the charter.
No, the answer is it does not. So was it your idea to establish the board?
As I testified, Senator, under oath, the establishment of the working group was a decision taken, a conversation that was had among multiple individuals at the Department of
Okay,
Homeland
so you're not going to answer my question. Ms. Jankowitz, Nina Jankowitz, she was appointed to run this disinformation board. How was she chosen?
Ms. Jankowitz was chosen consistent with practices for the hiring and vetting of political appointees.
Walk me through that process. Who was involved?
I don't know the full scope of that process.
You weren't involved in it?
I was involved in one piece of that process.
What was the piece that you were involved in?
I spoke with Ms. Jankowitz.
At what point?
As part of the standard process for political appointees, I spoke with Ms. Jankowitz.
What time frame would this have been?
This would have been, sir, I don't want to give you an incorrect answer.
It's okay, give me just a frame.
Early 2021.
Okay,
February.
January?
I don't recall the exact date, sir. I can get back to you on that.
Okay, January, February time period, perhaps. That would be early 2021. The Secretary signed the charter, I believe, in February of 2021. When did the Secretary sign off on Ms. Jankowitz being the head of the board?
Senator, I don't know that the Secretary signed off on Ms. Jankowitz or not. As
Oh, really?
I mentioned, I'm not aware.
He testified it was his decision.
I believe the Secretary testified that he was ultimately responsible for Ms. Jankowitz. I don't know.
So it wasn't his decision?
Senator, I just said I don't know the full scope of that.
Did you recommend favorably Ms. Jankowitz to the Secretary?
After speaking with Ms. Jankowitz, I was impressed by her expertise during our conversation and noted my recommendation to others in the department.
Were you, so you recommended yes. I think that sounds like it's a yes. You recommended favorably. Did you, at the time that you spoke with her and recommended with her, were you aware of her long history of comments on Twitter and other platforms of disinformation, anti-free speech rhetoric, and so forth, which has since become, I think it's safe to say, infamous?
Senator, I was aware of Ms. Jankowitz's expertise in the field of disinformation and was impressed by her expertise.
But did you know about these? Did you know about her many comments spreading disinformation about Russia, about the Trump administration, about conservatives? Secretary Mayorkas, just to by comparison, said he was not aware of any of this at the time. I'm just curious, were you aware at the time you recommended her to him?
Senator, in my capacity as Acting Assistant Secretary for Counterterrorism Threat Prevention and Law Enforcement Policy, I had not read all of Ms. Jankowitz's tweets, but as I said, was aware of her expertise in this.
Well, when you say you hadn't read all of her tweets, does that mean that she, I'm sure, has a lot of tweets, but were you familiar with the ones that have since become public?
I was not, sir.
Okay, you were not aware at the time. Did anybody bring those to your attention at any time before they became publicly released in this process, this vetting process?
Not to my recollection.
Okay, so somehow she got through this vetting process with no one, including all the way up to the secretary, apparently aware of what she had said on these public platforms. I find that sort of extraordinary. Was the White House involved in the selection of Ms. Jankowitz?
I'm not aware of the full scope of the process, or as a presidential, as a political appointee, the standard processes were followed.
So, to your knowledge, the White House was not involved. Is that fair to say?
My knowledge is I'm a political appointee. The White House was involved in my process, so I believe that is standard practice for the White House to be involved.
So so you think that they were involved in the selection of Ms. Jankowitz?
I'm not aware of the full scope of the hiring or vetting process. It was the same as pertains to other political.
Well, I'm just trying to get at what your knowledge is. So to your knowledge, I'm not asking you what you think may have happened, but to your knowledge, was the White House involved in selecting Ms. Jankowitz? Just yes or no?
I really don't know, sir.
Okay, you have no idea. All right. What's the current status of the Disinformation Board, to your knowledge?
Well, it's on pause.
And what does that mean exactly?
It means the Disinformation Governance Board never met. The Secretary has asked the Homeland Security Advisory Committee, the HSOC, to review how the department can most effectively address disinformation and how to do so in a way that protects civil rights and civil liberties. He has also asked that the HSOC review how the department can be as transparent as possible with the American public and increase trust in the work that we do. The HSOC was asked to conduct their review within 75 days, and while that work is pending, the Disinformation Governance Board, or the DGB, just is on pause. It's not meeting. There's not work underway.
Last question. I know there are other senators waiting to ask questions. Did the board ever meet, any members of the board ever meet with Twitter executives? We know we have minutes of planned meetings with Twitter executives to ask for cooperation in tracking speech. Did that ever happen at any point, to your knowledge?
I disagree with your characterization of...
Did the meetings with the Twitter executives ever happen, to your knowledge?
If I can finish, I disagree with your characterization of the purpose of a meeting that never happened. The meeting with Twitter never happened.
Okay, to your knowledge, it never happened. Listen, I've got to let other senators question. I'll just say that I regret that it has taken months to get the most basic information about this board. And again, we would know none of this, none, had it not been for a whistleblower who turned over these documents. Frankly, that is totally, totally unacceptable. Thank you, Mr. Chairman.
Thank you, Senator Hawley. Senator Carper, you're recognized for your questions.
Thanks. Welcome to each of our witnesses. I want to start with Ms. Caltes. Do you pronounce your name Caltes?
That's correct, Senator.
All right, thank you. In your testimony, I believe, ma'am, that you mentioned that unmanned aircraft systems, also known as drones, represent the fastest growing sector in aviation to today. I understand that as of September 2020, about 2 years ago, there were 1.7 million drones that were registered with the FAA, and that this number will only increase in the years to come. And that said, could you just take a minute or two and explain to us how the expansion of the drone use has impacted the current threat landscape, and how the FAA plans to grapple with continued disruption to U.S. airspace by drone users, by drone users?
Thank you, Senator, for that question. So what the FAA currently does to contribute to the security of the airspace...
Could you just speak just a little bit louder or closer to the mic?
Is that better?
That's better.
Never been accused of speaking softly.
All right.
Thank you, Senator. The FAA has been doing a number of things, working with our security partners and our non-federal stakeholders over the last several years as UASs continue to be integrated and grow across the economy, both with industrial users of the drones as well as hobbyists and industry. So things that we've been doing to help mitigate and work with our security partners and ensure the safety of the NAS, which obviously is the FAA's #1 priority, is to ensure as the drones are integrated into the NAS that it is done at a safe manner and does not affect the rest of the NAS and as well as passenger commercial flights. So things that we've been doing is we authorize and we put in existing what we call temporary 99.7s, working with our security partners who will request temporary air restrictions over certain events, who meet certain security measures and needs necessary. Some of those may be mass gathering events. We've talked here about stadiums, Super Bowl, and other types of events, the borders. There's other events that go on nationwide or throughout the year that we work with our security partners to put in also those additional air restrictions around those events. We also look at conducting tabletop exercises and also what we call TTXs, again, working with the state, local, tribal, and territorial and federal partners at when they're at these events and using such scenarios that if a drone would come into the airspace or if we have, as you heard of, say, careless or clueless or maybe a non-compliant or potentially a criminal actor of a drone, how would we actually respond? Who has those authorities? What does that response and coordination look like? And we've been working on that for the last several years. In addition, we have remote ID, which starting September of this year, manufacturers will be required to have all drones manufactured to have what we call a self-identifier or a license plate. So all drones manufactured after September will have to have that on all drones, and operators of drones will have to be compliant with the remote ID rule by September of next year.
All right, thank you. The second question, my second question would be one I'd address to each of you, and I'll take a shot at it if you would, please. Protecting our homeland security is of I think the utmost importance when it comes to addressing the threats posed by drones. Ironically, last week my family was at a beach together, and one of the visitors that joined us at the beach brought their drone, and set it out in front of us, sent it out over the ocean, some distance, and almost out of sight, and brought it back, taking pictures of us and others. Pretty amazing. And 2 or 3 days ago, I was back home in Wilmington, Delaware, and we're experiencing an epidemic of off-road dirt bikes. In Wilmington, all kinds of cities across the country, where these people get on the streets and they ride their dirt bikes all over the place and create mayhem and havoc. And one of the tools to try to stop that is to track them using drones. So actually, a drone can be used not just to support criminal activities, but actually to stop them, and I think we need to be mindful of that. But protecting our homeland security is of the utmost importance when it comes to addressing the threats posed by drones. And given that they can be used by criminals to conduct illegal surveillance and espionage, as well as trafficking of drugs and firearms. As such, close coordination with the Departments of Homeland Security, Department of Justice, Federal Aviation Administration is critical when it comes to mitigating these threats. Could each of you take a moment or two to explain how your respective agencies work together, not as a stovepipe, but as work together, and with your state and local counterparts to monitor and counter threats posed by drones? And Ms. Vinograd, is it Vinograd?
It is, sir. Sorry, it's a tough one.
That's okay. Would you take the first shot at that, please?
Certainly, and let me just say, sir, that I agree. The Department of Homeland Security agrees that drones have a variety of beneficial uses: emergency response, deliveries, recovery, investigative purposes, and so much more. What we're focused on is the malicious use of drones, whether intentional or unintentional. Your question about cooperation is critical because the Department of Homeland Security just could not utilize its current CUAS authorities absent incredibly close participation with our federal partners, to include, for example, the FAA. As we seek the Secretary's authorization, for example, to designate a covered facility or asset, which would then allow us to engage in CUAS activities, we are coordinating every piece of that authorization with the FAA, for example. When we get a request for CUAS activities to protect a SEER event or an NSSE event or a mass gathering at the request of a state executive, that request goes into an interagency working group that reviews the risk, reviews the threat, reviews capabilities, reviews who is best positioned to respond, and more. We got a question earlier, sir, and I'll stop here, about TFRs, or temporary flight restrictions. DHS works incredibly closely with the FAA. When DHS or parts of DHS request a TFR with FAA to implement that TFR, and where necessary, to grant waivers to allow for authorized activity to include First Amendment protected activity as well.
All right. Thank you, ma'am. Is it Wigman? Wigman?
Wigman, yes, sir.
Wigman?
Yes, sir.
Okay. Mr. Wigman?
Yeah, so I would just heartily agree with that. I think the counter-drone business is very much a team sport. Everything we do, we work hand in glove with DHS and with FAA. We have to, whether we want to or not, to work on TFRs and so forth to get them. So everything we do, we work together. So horizontally, there's a lot of collaboration. And then also we're starting to do more of the, what I'd say, vertical with our state and local partners, including in Delaware. And my understanding is the Delaware State Police is part of our state and local working group on drone activity. And so that's a group that we have and convene. And if we get the authority that we're asking for today, we'll be working much more intensively with state and locals all across the country, both on their detection-only activities, but also with the pilot program that we've described. So this is an activity where law enforcement and Homeland Security officials are working together all the time, together with FAA.
All right, thank you. My time's expired. We'll have the opportunity to submit some questions for the records. I have several more I'd like to offer. Thanks so much for joining with us today and for your collaboration and for your commitment. Thanks so much.
Thank you, Senator Carper. Senator Langford, you're recognized for your questions.
Mr. Chairman, thank you. Thank you to all of our witnesses as well today and for the ongoing work. I do have some questions about the collaboration you all were discussing at this point. When I was visiting with some of the folks at our southern border several months ago, there's some of our border stations that we're trying to get counter-UAS equipment up and running and operable. In one of our areas along the border, we had over 10,000 incursions in just that area with UAS coming across the border from Mexico into the United States, and they were very eager to be able to get that. When I asked, what's the issue? The equipment was there, the people were there, they were waiting on authorization, and there was an ongoing dialogue between DHS and FAA to be able to discuss how we're going to get this up. So literally the equipment, the people, the need, everything was there. So my question is about this collaboration, how long does it take? In this particular instance, we had a situation where that same equipment along the border was being used in a different region of the border and had been used for a while, but in this particular region it took months to actually get counter-UAS equipment up and working in that area. How do we speed up this process? Where is the slowdown?
Senator, as noted earlier, I share your concern about the malicious drone threat at the southwest border. I'll turn to my colleague from FAA in a moment. As you know, sir, the Secretary of Homeland Security has authorized 3 areas of operations along the southwest border as covered facilities or assets. So we have 3 up and running, if you will. There are 4 additional AORs that are pending. We have taken significant steps internally to make the process internally more efficient between CBP and the Program Management Office, which is part of my team. In addition, we have started doing safely concurrent processes with FAA such that this can move as expeditiously as possible. There are 4 areas of operations. I don't know if it's one of the ones that you visited. 4 areas of operations still pending. I will tell you it is a priority for me. It is a priority for the Secretary to get these authorized as quickly as possible.
So what is the holdup? Because this is months when that same technology is used in other places along the border. Where is the spot where it's getting stuck?
So I'll turn to my colleague from FAA in a moment, but as these AORs are in the process of being authorized, there is a lot of coordination with the FAA, and each covered facility or asset, sir, is different. So there are different complexities in each area of operations. Now, again, we are committed to doing this quickly. The threat is significant, but each area of operations is different, which is why we coordinate with the FAA on.
Right, I get it. We're still back to the same spot. Defining quickly, this seems to be defining quickly along geologic time rather than clock time on it, because it's taking months in process. And when I've interacted with the secretary, it's on FAA's desk, and then I talk to FAA, and they'd say, no, it's on the secretary's desk, and it just seems to be getting lost. What I'm trying to figure out is how to get this unstuck.
So I can't go into further details in this hearing except on one point. Okay. On one of the AORs, sir, it's a matter of just a few weeks at a maximum. The others are a little bit more complex, and I'd be glad to speak with you in a closed session just more specifically about what that looks like, but we are committed to doing this with urgency and with care.
Great, thanks. How long does it take to be able to get one of these coordinations done with FAA to be able to look at an existing technology that's out there in a new geographic region?
So it varies based on the technology and the location and the complexity of the request that we receive. So in some cases, it can take just a matter of days to issue a TFR, but then others it does take longer depending on what the actual area is and other TFRs that may be in the area. And
right, can you define longer for me, just so I get it? Because a matter of days I can get. What does longer mean?
So I'm not in the area of issuing of the TFRs, so it varies. So like we are working with our security partners now on also other areas of the country where they're trying to get TFRs. So it can vary as long as we have the information, working closely with our security partners in getting that. I can't give you a definitive how long because the operations and all vary.
Here's my challenge on this, and I'll just take one specific region in the southwest border. When I go there and I see the people, I see the equipment, everyone's trained, everyone's ready to go, and they're waiting on a piece of paper to be signed somewhere in Washington, I get on the phone and start calling around and saying, where is this? How do we get this unstuck? Because they're dealing with, literally at that point, thousands of UAS coming across from Mexico carrying narcotics, doing surveillance. We have the technology sitting there. I'm just trying to figure out, how do we get this unstuck? Because it's on someone's desk moving, doing something. If there is a need to assist in process, this committee is very engaged to be able to help get processes unstuck, but we're trying to figure out why it's still stuck.
Senator, I try to be in the business of unsticking things as well. And I will tell you that for the one that I mentioned that is forthcoming in just a small number of weeks, what we're waiting for in that particular context and in others is to ensure that this equipment can be safely used and operated in that airspace. So I'm happy to follow up with more details in a closed session, but we, again, deeply committed to ensuring that this first AOR happens in a very small number of weeks and that the other additional AORs that, again, are just more complex from an airspace perspective are unstuck quickly as well.
Yeah. How long has that one been pending? You said the one that's going to get unstuck in weeks. How long has when it first started?
I don't have the exact date in front of me, sir, but it's been, when you say first started, it's been just a few weeks since we could move to this next stage of basically looking at this particular airspace and the complexities there and ensuring that the equipment could be safely used. But I can get you a more specific answer.
That'd be helpful.
In writing.
Let me ask the same question when we deal with the Bureau of Prisons and how this is managed. Obviously, a huge issue with cell phones being snuck in, individuals that are actually operating their gangs and criminal activity, stalking people that they had threatened outside of that facility from inside the facility, bringing narcotics in. This has been a big issue for our Bureau of Prisons. What would slow us down now? Those are fixed locations, most of them in remote areas. What would be the challenge of trying to get this counter-UAS across all of our Bureau of Prison facilities, starting with the most remote? Why isn't that already happening?
So we're working on that. We've deployed technology at a number of prisons. I know it's several, and I think there's another 20 that are going to be coming on board. It's really just a question of getting people trained, getting the technology, working with the FAA on the TFRs and so forth. So, look, I understand your impatience and share it. So we want to do this because it is a huge problem. So I share your view, and we're working with BOP, which is definitely concerned about this issue. We just had charges this past week in a prison in Texas where people were smuggling in contraband into the prison, and it's not the first one. There's others. So I share your concern, and BOP is ramping up.
Okay, that's helpful. I would say good, except that this is something we've talked about often around this dais to try to say what is the slowdown. We're always trying to figure out what is the issue, because we'll allocate funds, we'll do the studies, we'll do the pilots, we'll approve all the process, and it seems to be years to actually get to execution on something that should be pretty straightforward, especially a Bureau of Prisons area that's very remote, that we're not dealing with the complexities of being in a city, this one shouldn't just be as hard as it seems to be. So, Mr. Chairman, thank you.
Thank you, Senator Langford. Senator Scott, you're recognized for your questions.
First, I want to thank Chair Peters and Ranking Member Portman for holding this hearing on a critical, important topic. And plus, I mean, I clearly, from listening to y'all, you know the importance of this, and you're taking it seriously. So, as we know, Communist China funds technology like drones to spy on Americans and steal our data. I have proposed legislation such as the Counter-Chinese Drone Act and the American Security Drone Act to help protect national security and the privacy of American citizens. I'm proud to have led the effort to pass the American Security Drone Act in the Senate, but I think we have to go further and pass the Countering CCP Drone Act. The legislation is the next step to ensure that the federal funds from the Federal Communications Commission cannot be used to obtain communications equipment and services provided or produced by Communist China's drone company like DJI. So I've got a few questions on the reauthorization of the Preventing Emergency Threats Act. So, Mr. Weigman, I said it right? Wigman?
Yes, sir.
Yeah, I know I practiced it. I said it the wrong way. Current law already waives certain specific provisions and prohibitions under Title 18 for action taken by DOJ, DHS against drones. This proposed bill waives all of Title 18. So why do you need to waive all of Title 18, and why not just keep the existing waivers in place?
So a couple of things. DOD and DOE have a broad Title 18 waiver, so it helps us interoperate with them if we have the same authorities they have, and we think so. That's one. Two is, while you're correct that our current authority for DHS and DOJ only extends to certain provisions in Title 18, and we've been able to use that effectively thus far. We can't predict, as this is a changing technology landscape, that other statutes could come into play in the future. So we would be back in Congress asking again if there's some new technology that's going to implicate a different statute that we weren't thinking of. So we think the cleanest approach, given that we don't think that law enforcement officials, using this technology we've all talked about here today to try to prevent threats from drones, it shouldn't be criminal at all. So it shouldn't be any criminal provision that they're subject to, rather than just a few statutes. So we just think it's a cleaner approach. We're obviously happy to discuss that with the committee if that's not their view, but we think it's cleaner to have the same authority that DOD and DOE have, which is a full sweep.
Do you have examples where you needed it? If this wasn't in place, or where have you needed this in the past?
A broader. Thus far, as I said, we've been able to work with the existing exemptions that we have from specific statutes. We can't predict necessarily whether in the future, as technology changes, whether other statutes could come into play.
Okay. So Senator Langford talked a little bit about the prisons. So we know the use of drones over prisons is a real threat.
Yeah.
They've been used to drop drugs, weapons, and other contraband into inmates. Drug cartels, we know, are really using drones for smuggling contrabands into across-the-border prisons and related surveillance. How will this bill improve law enforcement efforts to counter this threat?
The counter-drug threat?
Yeah, to deal with the prison fight, issues over prison. How will this bill
on prisons,
change anything?
We already have the authority to protect our prisons, so it would extend it. Is the key. The key thing is it expires in October if we don't extend it, so we would not have the authority unless we get the extension.
Other than that, it doesn't really change.
But other than that, we have the authority in prisons, and so we're good. We just need to extend that authority for prisons.
Okay. All right, Mr. Vinograd. Under the proposed reauthorization of the Preventing Emergency Threats Act, it authorizes a limited pilot program under which DHS and DOJ, in consultation with the Department of Transportation, could designate certain state and local law enforcement entities to use counter-drone detection and mitigation authorities. Can you talk about the selection process for this pilot program and how state and local entities would be selected? And by the way, have you talked to agencies in Florida?
Senator, thank you. I'll turn to my colleague from the Department of Justice in a moment. What we are seeking in this legislation is two things for state, local, tribal, and territorial partners. Number one is the ability for SLTT partners, excuse my acronym, to engage in detection of drones or UAS. In addition to that, and I should say compliant with all federal standards and safeguards. Right. In addition to that, what we are seeking is a 6-year pilot program for SLTT partners to engage in mitigation. That selection process would be an interagency process. These individuals would comply with federal standards and certifications. They would use equipment from an authorized equipment list that's been coordinated with the FAA and FCC. And we believe that this is critical, such that SLTT partners, as the first responders on the ground in Florida and elsewhere, would be able to take urgently needed action to detect and mitigate drone threats. And I will turn to my colleague from the department.
Yeah, and I'm going to look, if it's okay, in the back row to see if we've been talking with anyone in Florida about the potential. Yes, we have.
Is that typically through what, the sheriff's departments or police?
Daytona, I'm hearing that we have talked to them about this. So it's going to be, you know, as we select cities around the country to participate in the program, it's going to be their level of interest, right, of people we already have a
It's
working
really
group,
how much they're going to drive.
their expertise and so forth, and if they would apply, and we'll see how that process works. We haven't exactly figured out what the criteria are or how we're going to select jurisdictions to do it, but I imagine it would be in locations all over the country and build up.
Do any of you, you know what I talked about it with DJI, the drones, do you all have thoughts about whether we ought to just blanket outlaw the ability for a Chinese company to be able to sell drones in this country? Or whether the federal government ought to be able to buy them or not? Do you guys have any thoughts on that?
From the department's perspective, we share your concerns about China generally. And Chinese manufactured drones. So Senator, DHS has issued guidance internally that prohibits the procurement of small UAS manufactured by foreign countries. There are some limited circumstances in which waivers may be granted, but generally we share your concern about Chinese manufactured drones.
Yeah, so we're working, the problem is that right now, as you know, they dominate the market.
Yeah.
And so we're working.
Down some.
What's that? We have
Down
some.
a little bit, but
They've
not
got
enough.
a huge chunk of the market, and
Yeah.
so if we need to use drones for law enforcement purposes,
Yeah.
they're kind of the main game. We were working to transition away from that. So it's just, again, no, there's impatience, it's a question of time. And in the interim, we're taking steps to mitigate whatever risks, supply chain risks or others from use of the drones, but eventually we just want to transition away from it. So the waivers that Sam mentioned are necessary for that purpose so that we can continue, they do serve a useful purpose for all manner of things that we do. It's not ideal, but we're trying to transition away from them is how I would say it.
From the FAA's perspective, we're really responsible for the integration of drones into the national airspace and testing of the drones to ensure the safety as they are integrated, but we don't have a position on the purchasing of or acquiring.
Okay. Mr. Peters, I got one quick question. Ms. Vinograd, did you see this stuff that came out in Ukraine that DJI drones were being tracked? Have you guys looked into that at all, or is that classified? Do you know?
I have seen that, and I'd be glad to follow up in a closed hearing.
Okay,
for that.
yeah, that'd be great. I'd love to learn what happened on there.
Certainly.
Thank you.
Thank you, Senator Scott. Senator Rosen, you're recognized for your questions.
Well, thank you, Chairman Peters. Appreciate you holding the hearing, and I appreciate all of you being here today and what you've been working on. And I want to focus on protecting our stadiums, because my home state of Nevada, it's the entertainment capital of the world. We're quickly emerging as a sports capital of the world as well. We have a new Allegiant Stadium, home of the Raiders, so Las Vegas is the first city to secure the NFL Draft, the Super Bowl, and the Pro Bowl all at once. And this, unfortunately, continues to make Las Vegas a target-rich environment for bad actors. So since the September 11th terrorist attacks, Congress, executive branch, you have recognized the need to protect stadiums and sports events. And the FAA initially imposed, like you talked about, temporary flight restrictions, TFRs, over stadium events, including for unmanned aircraft. And Congress subsequently strengthened and codified these requirements. However, sports leagues have reported an increase in violations of flight restrictions by drones. So, Mr. Chairman, I ask that I be permitted to enter into the record a letter from a coalition of sports organizations in support of the administration's counter-UAS proposal.
Without objection, will be entered.
Thank you. So, Ms. Caltes, as the FAA considers new drone policies, do you think it's important to take into account these long-standing protections for stadiums, ensure that federal policies keep up with evolving threats? How do you plan to do that?
Thank you for your question, Senator. The FAA is, yes, we do agree that as the technology and as continue integrating drones into the airspace, that the ability for the detection and then, when necessary, mitigation is in place as well. So we are working closely with our stadium stakeholders to ensure, as you mentioned, we already do have standing TFRs for the NFL, Major League Baseball, NASCAR, as well as the Division I colleges. And then we also work very closely for the Super Bowl and other types of larger events to ensure that we put the appropriate air restrictions around those mass gathering events that are held at stadiums and other venues to both ensure the safety of that event and security, but also to ensure that the safety of the airspace over that event.
So let me ask you this follow-up then. You have there's draft legislation from the administration that does extend the authorities for critical infrastructure, but it doesn't specifically mention stadiums. You're talking about all the things that you're already doing. Shouldn't we be specific in identifying stadiums and other types of critical infrastructure so we're sure that we want to avoid confusion, and we're sure that communities have the resources to protect themselves? Ms. Caltes and then Ms. Winograd.
So yes, the legislation specifically says critical infrastructure, and we did not define exactly which sectors or entities within the critical infrastructure sectors. I would say I would leave that up to Congress if they wanted to give us more specifics and mention, but we take that as it's all entities, because critical infrastructure encompasses, in addition to stadiums, as you know, it's chemical facilities, it's the energy sector, it is dams, it is a whole host of different sectors that may want to come and petition through DHS or the Justice to the FAA to get both temporary restrictions or permanent restrictions, in addition to being able to use detection equipment and then eventually maybe mitigation. I would defer to my DHS colleague if she wants to expand on that.
I concur with my FAA colleague. We have no objections to more specificity. We just want to ensure that all critical infrastructure owners and operators, to include stadiums and sports venues, have the authority that we're requesting in the bill.
I'm just worried that there's going to be confusion, and so we can at least maybe define as a minimum a certain group, allowing for the flexibility, of course, to add more as needed. So we'll continue to work with you on that. But I do want to build on what Senator Scott asked about the pilot program to extend the counter-drone capabilities to work with state and local law enforcement, again, protecting all the critical infrastructure. And so, first of all, do you agree that the pilot program should include stadiums? I think you do. You've probably been talking to, as you say, you've been talking to Florida. Mm-hmm. We have a great fusion center in Las Vegas. We have a lot of things to protect there. And so, have you been speaking with anyone in Nevada? And do you believe that the training and surveillance should be shared across these multiple law enforcement agencies, and that's a good thing to involve the communities?
Yes, I agree, and I'm just going to look again in the back row to see if we're in touch with folks in Nevada. Yes, we are in touch with folks in Nevada, and look, right now we can only protect, the Super Bowl, the World Series, et cetera, and one of the main purposes of the bill is, there's a couple thousand NFL games every year. Yeah. There's 20,000 baseball games every year. We're only covering tiny, the super high profile, and so the big advantage of this state and local pilot is to allow that force multiplier, right, for the people who are on the front lines, be able to protect those venues for the ordinary game, that's going on, and so that's a big piece of it, including in Nevada. And I fully expect that the jurisdictions that we participate in the pilot would be scattered across the country.
I think your force multiplier, that's the way we should look at our state and local communities, as force multipliers. You can't do it all alone. I have about a minute left. I'd just like to quickly move on to cybersecurity, because we know that the drones really present significant cybersecurity risks. Of course, country of origin, as we've talked about with China, manufacturing. But there's malicious actors. They can exploit data. They can spoof our GPS. They can hijack control of drones that are necessary, law enforcement drones perhaps. So, Assistant Secretary Winograd, can you talk about some of the specific threats? And could you list them in what you might think is the highest threats we need to be worried about first to the least, if that's possible? I mean, all threats may be not quite equal.
Senator, just to clarify, cybersecurity threats or drone threats more broadly?
Cybersecurity threats to the drones, I guess.
Certainly. Well, Senator, you mentioned several key ones, which are the exploitation of information on that drone or information that is being transmitted between the command and control center. Just to clarify, our CUAS authorities, the hearing today is about counter-UAS authorities. Your question is more specifically about drones. Moving back to the subject of the hearing, which is the counter piece of it, how we stop this stuff. We only, when we are countering UAS, intercept the signal between the command and the control center. And that is the only information that we interrupt and that we, in certain cases, retain. When we look at drones being used for malicious purposes, we are certainly concerned about a malicious actor of some kind trying to engage in some kind of cyber attack to change the course of that drone, weaponize it, and or use it for its own malign purposes, like surveillance, like intrusion into an unauthorized facility and things of that nature. So from a counter-UAS perspective, again, we are focused on the signal between the command and control center, and then from the actual drone perspective, we are very aware of cybersecurity risks that could allow the drone to be manipulated for a range of malign purposes.
I guess we'll have to work on that with CISA. I'm just concerned that making sure that our state and local communities understand which threats they have to deal with, the highest threats going down, so that we can be sure to protect the ones we love. Thank you, Mr. Chairman.
Thank you, Senator Rosen. Senator Padilla, you are recognized for your questions.
Thank you, Mr. Chair. Before I ask my questions, I just want to be very clear that the potential threat posed by UAS is one that Congress must address before the existing authorities expire. We absolutely agree on that. I know in California we've seen how rogue UAS can disrupt critical functions, including wildfire suppression efforts. So my questions are not related to the need for reauthorization, but making sure that we do so in a responsible way. Now, the first area of questions has already been covered by Senator Scott, and that had to deal with the sort of broad exemptions to Title 18 that are called for in the administration's proposal. I know there was a recognition and a back and forth of, that's not currently the case. There's a lot of specific exemptions, and it may not be pretty, it may not be easy, but you're making it work. And so there's more than one way to get this done. Instead of just asking that question over again, I will follow up, Mr. Wiegman, with this. Title 18 for the U.S. Code includes prohibitions against, for example, committing war crimes, intimidating voters, and engaging in video voyeurism. So I understand why the Department of Justice and DHS might need to be exempt from the Wiretap Act, but why do you need to be exempt from prohibitions against the examples I just gave?
Yeah, we don't. Although, again, to be honest, none of those activities would be authorized by this statute, because you can only take under the statutory regime those actions which are necessary to detect and then mitigate a credible threat. And so it's hard for me to imagine a voyeurism or war crime coming into play there. So the statute would not give protection against those offenses because of the way it's structured, right? Well, it would not exempt you from those offenses. It would, because those would never come into play.
I hear you, but sadly, as we've seen, from administration to administration, interpretations and philosophies can shift. And so what we do put into statute in terms of exemptions does matter. And I think it is critical and important. A question in a different area, it's whether it's broad exemptions or more specific exemptions is one thing, but we're also discussing the proposal to have a reauthorization that's permanent and not one with a sunset provision. The proliferation of drone usage, as well as the rapid development of drone technology itself, so it's the technology and how it's applied and used, demonstrates why the government needs to have clear authorities, in my opinion, to engage in UAS mitigation activities. But as I mentioned, the pace of technological development, as well as the ever-growing uses for drones, including for valuable journalistic and civic engagement purposes, seems to suggest that there's considerable value in Congress regularly revisiting this area of the law. The administration's proposed legislation seeks a permanent CUAS authorities rather than including a sunset provision that would require not just Congress, but the executive branch to come together in a few years to evaluate how well the expanded authorities called for in the statute are working. And happy to debate whether it's 3 years, 5 years, 7, whatever the time frame makes sense. But Ms. Vinograd, let me direct the question to you. Why shouldn't we all be required to revisit the broad authorities being granted in this bill in a few years?
Senator, just to be clear, what we are seeking in this legislation is the lack of a sunset clause for most of the authorities. The SLTT pilot program, we are not requesting indefinite authorities for. The sunset clause, as it currently stands, is really impeding the department's ability to effectively use our authorities insofar as it makes it incredibly difficult for us to engage in multi-year planning, multi-year testing, and things of that nature. We agree that there's a critical need to regularly engage with the congressional branch on how these authorities are being exercised. Under the Preventing Emerging Threats Act of 2018, we are required to report to Congress every 6 months, which DHS has done judiciously. In addition, in this bill, for the SLTT pilot program, 2 years after the enactment of this bill, we are also required to report to Congress on just that SLTT pilot program.
Yeah, so you may disagree, but what I'm hearing is an argument for a longer reauthorization, not a shorter one. But I still believe in the power in the sunset mechanism to force these conversations. That then keeps us from, talking every day, every week, every month, not just every 6 months, not just every 2 years. But as I mentioned in my preface here, the continuously evolving technology, the innovation makes additional things possible, additional performance and capabilities, let alone the growing number of uses of the technology. I think more regular required conversation from Congress to Congress and from administration to administration would be worthwhile. So I know it's been a long morning for all three of you. I will leave my comments and questions at that, but look forward to working with you as this proceeds. Thank you, Mr. Chair.
Thank you, Senator.
Thank you, Senator Padilla. Senator Sinema, you're recognized for your questions.
Thank you to our witnesses for joining us today. The counter-drone, or CUAS, authorities expiring this October are critical to our homeland security. These authorities allow DHS and DOJ to protect Arizona's critical infrastructure and communities. As chair of this committee's border subcommittee and the Commerce Committee's aviation subcommittee, I'm also keenly aware of the threats posed by drones to our nation's borders and airports. In Arizona, cartels are using drones to smuggle drugs across the border in an attempt to evade law enforcement. And across our nation, there are too many examples of drones blocking flight paths and even shutting down airports. We must maintain and enhance our nation's CUAS capabilities while also safeguarding privacy and the rights of legitimate drone users. I look forward to working with the chairman, the administration, and my colleagues to do just that. So my first question about future threats is for Mr. Wigman and Ms. Vinograd. Drone technology is rapidly evolving, and while most drones currently rely on RF technology, in the future, more advanced drones may become the norm. At DOJ and DHS, what are you doing to prepare for the drone-related threats of the future, including autonomous unmanned systems and drone swarms that could conduct synchronized operations? And as Congress considers reviewing the existing CUAS authorities, what can we do to help you research and mitigate these threats?
Senator, thank you. As you mentioned, the technology is evolving incredibly rapidly, and that is why the Department of Homeland Security, we have designated research testing and evaluation efforts. Sorry. Senator, we agree that the technology is evolving incredibly rapidly, and what the Department of Homeland Security is committed to is trying to stay ahead of that evolving threat. We do so through our Science and Technology Directorate, where we are engaged in a significant amount of critical research, testing, and evaluation, such that we can try to stay ahead of the curve as it pertains to the evolving technology. In addition, as my colleague Mr. Weigman mentioned, we are seeking exemption from Title 18 such that we can ensure that we have the ability to keep pace and or stay ahead of the evolving threat environment as this technology rapidly increases and candidly proliferates the kinds of threats that drones may pose to the American people and to the homeland.
Yeah, I don't have much to add to that other than we obviously work with our colleagues at DHS and DoD also in technology kind of working groups to make sure that we're doing the best we can to have the state-of-the-art technology to counter this threat.
Thank you. Ms. Vinograd, as chair of the Border Subcommittee and the Aviation Subcommittee, I'm particularly concerned about the threat that drones pose to our border and our airports. If the current CUAS authorities expire in October, can you discuss the impact that would have on our border security?
The expiration of existing counter-UAS authorities would be catastrophic from a border security perspective. Our counter-UAS authorities currently allow for critical counter-UAS operations at our borders, and the expiration of those authorities would allow a range of adversaries, including transnational criminal organizations, to increase their malicious use of drones to engage in smuggling, surveillance, and other malicious activities.
Thank you. My third question for Ms. Vinograd and Ms. Caltes, can you describe how the administration's legislative proposal would help protect airports and flight paths from drones, and specifically, how do the current gaps in the federal government's CUAS authorities hinder your agencies from achieving this?
I will say that of all the things that keep me awake at night, I am one that is foremost on my mind is the potential for a major tragedy at an airport. We currently, at the Department of Homeland Security, work in close partnership with the FAA at airports. However, DHS, the Transportation Security Agency, or TSA, lacks the authority to engage in proactive or persistent CUAS operations at airports. What that means is TSA is not authorized to be on the ground at airports engaging in proactive detection and as necessary proactive mitigation. I will tell you just from a threat perspective, we've had 2,000 sightings of drones in and around airports since 2021. In 2021 and 2022 year to date, we've had 64 evasive actions by aircraft, including 4 commercial carriers taking evasive action, Senator. We've had 30 airport disruptions just in 2021. This already amounts in significant economic damage and a potential for a real loss of human life. I'm very concerned about the lack of explicit authority at airports. That is why we are seeking explicit authority for TSA to engage in proactive and persistent detection and mitigation in close partnership with FAA.
And to build off of my colleague from DHS, obviously the number one priority for the FAA is the safety and security of the airspace. And around airports, we too are very concerned about the number of drone sightings that we consistently see across this country. We're working very closely with our DHS partners, and the FAA is supportive of expanding the authorities to TSA to give them the authority to be able to do not just the detection, but the mitigation if necessary at the airport environment.
Thank you. My next question is for Mr. Wigman. Like all technologies, drones hold both promise and peril. The same drones that our adversaries could use to surveil a sensitive government facility can be used by journalists to shoot footage for the news and to hold government accountable. So I know that DOJ has devoted considerable time and resources to ensuring that privacy and civil liberties are protected during CUAS operations. Can you discuss some of these safeguards, and how often are drones that enter restricted airspace actually interdicted, and when they are, what data is intercepted and for how long?
Okay, so under the statute, we can only intercept data that is necessary for countering a threat. So as I mentioned in my opening testimony, what we're typically talking about is, I have a list here of the types of data, the drone vendor and model, the drone and controlling device serial number, the geolocation of the drone, the location of the controller, and the most recent takeoff location and home location. So we're not talking about content of communications. We're talking about metadata, signals, information, essentially, that the drone is generating that allow us to find out where it is, where it's going, where it's been, and who's controlling it, so that we can hopefully, interdict it. once we collect that information, in the ordinary course, if it's not of any use, we discard that information right away. But under the statute, we can only keep it as long as is necessary, and in no event longer than 180 days, unless it's necessary to keep it longer for a specific purpose, like for a criminal investigation, if someone has violated airspace and we need the information in order to pursue a criminal investigation or prosecution. So all of this is laid out in existing law, in the statute, the restrictions on what you can collect, how long you can retain it, and when you can disseminate it are all in the statute, and those would be carried over under the new bill. So we would continue all of those same privacy protections under the new bill, and they would also be applied to state and locals. So to the extent state and locals are engaged in the same activity under the pilot program, they would also be bound to respect all of those privacy protections. So I don't know if that answers your question.
Yes, thank you. Thank you, Mr. Chairman.
Thank you, Senator Sinema. I'd like to take this opportunity to thank our witnesses once again for participating in today's hearing and in discussing the administration's proposal to both extend and expand current authorities to counter UAS to protect our homeland from serious threats posed by unmanned aircraft systems. As we heard today very clearly from each of our witnesses, a malicious actor could deploy UAS to cause a catastrophic incident at any time, and we cannot and must not wait for that incident to occur. As chairman of this committee, I'll work to ensure that these authorities do not lapse in October, so our federal law enforcement partners can continue out their very crucial missions to protect us from these threats. I also plan to introduce legislation in the very near future with Senator Johnson that both extends and provides a careful expansion of these counter-UAS authorities. The record for this hearing will remain open for 15 days until 5 p.m. on July 29th of 2022 for the submission of statements and questions for the record. This hearing now stands adjourned.